Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law. And today's guests are Doug Laycock, who is the Robert E. Scott Distinguished Professor of Law Emeritus from the University of Virginia, and Rick Hasen, who is the Gary T. Schwartz Endowed Chair in Law at UCLA Law, also has a Professor of Political Science appointment by courtesy. So welcome to you both.
Thank you.
Really excited to have you on the podcast to talk about the 6th edition of Modern American Remedies, Cases and Materials that will be published by Aspen very shortly, it looks like. And I know, Doug, that you were originally the author of the first editions of this authoritative book, viewed as the leading book in the field of remedies. And so why don't you tell us a little bit about the evolution of the book from the beginning?
I took over Owen Fizz's injunctions course when I began teaching at Chicago, and when I moved to Texas, we converted it into a remedies course. And I was using someone else's casebook, but producing more and more supplemental materials, and I began to feel guilty about making students buy the book. And so I finally took the plunge and tried to cover the whole field. It was 9 years from the first supplemental materials to the first published edition. From the beginning, the idea was to organize the book in terms of remedies categories. Some of the other books, especially in those days, this is 40 years ago, 1985 was the first edition. In those days, most remedies books were organized in terms of the rest of the curriculum. There would be contract remedies and property remedies and tort remedies and remedies for different kinds of torts. And one book had 6 cases on trespass by digging and 3 cases on trespass by dumping. But it was hard to work out. And the organization of the first edition was pretty awkward in places. And so much of the evolution of the book has been smoothing that out. And I think, the last 2 editions, the organization hasn't changed much, only at the detail level. I think we've got it pretty well put together now. And so the chapters are compensatory damages, punitive damages, injunctions, choosing between the two, choosing between damages and injunctions, restitution, declaratory judgments, enforcing the judgment, attorney's fees, remedial defenses, and group remedies or class remedies. And so that ambition took a few additions to work out, but I think that has been largely achieved. The other thing we've always tried to do in this book, and this too has gotten better over the years. I know a lot more at 77 than I did at 38. We try to provide a lot of information in the book. We try to start class discussion from a more educative level, and we don't expect students to remember everything that's in the notes, and we say that very clearly to them in the preface, and I assume most teachers take the same view, but it enables the teacher to emphasize what she wants to emphasize. The basics are kind of covered in the notes, and so class discussion can take off from a higher level. Those are probably the 2 most important things I was trying to achieve in the book. I call it Modern American Remedies. We skip over some historical issues that still get a lot of attention, but really have become settled and don't matter much so anymore. So we assume a widespread use of injunctions, including structural injunctions. We assume a generally applicable law of restitution. We do a fair amount with the basics of law and economics, pro and con, but we don't get very deep into it. We don't make it, certainly not mathematical. We don't make it difficult for students, but we bring it up where it matters or where it's relevant. So those are the main things about this book. And I think the execution has gotten better with each edition, and it's certainly gotten better with the addition of Rick as a co-author.
Well, thank you for teeing up Rick. And Rick, I want you to share with us what made you join the book and what have you been delighted to add to this process and the foundation that Doug laid.
Well, it's great to be with you. And the way I got into teaching remedies was that I was Californian, and my family was here. My wife's family was here. We had a new baby, but we were living in Chicago. And an opportunity came up for me to visit at Loyola Law School in Los Angeles. And the Associate Dean, Lori Levinson, I think is also an Aspen author, wrote to me and said, well, would you be a podium visitor and teach remedies? 8:10 to 10:10 p.m. Tuesdays and Thursday nights. And I enthusiastically said yes. But because it was a really good
time slot.
And then the next question was, what's remedies? Because I taught torts and I taught contracts, but I never took a remedies course. There was a constructive trust question on the California bar, and I think I passed the exam despite my answer to that question. I really didn't know anything. And so I asked around, and people said, well, you got to get Doug Laycock's book. He's clear, he's got interesting cases, and he's got a great teacher's manual. And that all turned out to be true, especially the point about the teacher's manual, which we've continued, that we already have the teacher's manual ready for the 6th edition. And so I went in as a student, and I started peppering Doug with questions. questions because I was a novice and I didn't know anything. This was 1997, and Doug and I struck up a friendship over email. He was always very willing to answer my very naive questions about things. And, over time, I developed a little bit of expertise in the area, and to the point where Doug and I are now thousands of emails in communication with each other because we not only have this project. I'm now I was on the 5th edition now, on the 6th edition, but we're also doing a tort remedies restatement, which I know we'll talk about. I found the process of learning remedies from Doug just to be such a joy, to take something that's so arcane and difficult and to make it clear and functional so people can understand actually what's going on, and they can not be intimidated by hearing words like replevin or trover or whatever it is that waive the tort and sua sums it. We strip all that language out. We say, here's what the court means. I've tried to continue that tradition with Doug of not hiding the ball. There's still a lot of detail. It's still very complex, but it's not complex for the sake of complexity.
And now that you are both happy and proud parents of the 6th edition that will be published in June of 2025, tell us a little bit about what's new to the 6th edition. What can those who are currently teaching remedies look forward to in this new edition?
Well, one thing that Doug mentioned is that if people have used the 5th edition, the structure is the same. The notes are completely updated. There are some new cases, including cases on injunction bonds and a really important case called Jarkissi from the Supreme Court on the right to a jury trial. But the structure will be familiar. I'd say, in terms of the things that are new in this edition, we have a lot of important updated notes on big hot topics in the law, including things like universal injunctions, which the Supreme Court is considering this term in a birthright citizenship case. We have a lot of materials on the Supreme Court's shadow docket, stays and things like that. But we also keep up on private law. So this is a book that's appropriate for public law and private law. Updated the notes in both of those areas. The other place where we've really innovated, and maybe Doug wants to talk more about this, is that we've incorporated significant portions of the restatement third of tort remedies, for which Doug and I are the co-reporters. That project is more than 3/4 done, and it's a kind of distillation of some of the rules as applied to tort, but that can be thought of more generally in a way that I think takes the clarity that Doug brought to the casebook and extends it so that it's available to judges and to practicing lawyers. Doug, I don't know if you want to add anything on the remedies restatement or anything else.
Well, we did not include in the book any drafts of the restatement that have not yet been approved by the council and the members of the American Law Institute. So if it's just our opinion, it's not cited or quoted in the restatement. But as Rick said, about 3/4 of the sections have been approved now, and through all the stages of the process. And where appropriate, we cite those or quote those briefly. So we have the American Law Institute's current position on a wide range of remedies issues, especially compensatory damages, punitive damages, and injunctions against tort. I think that adds something useful, and it also helped anchor us a bit as we work through the notes. And as Rick said, we reviewed all the notes line by line and updated pretty extensively.
What would be some of the most significant changes that are in the third restatement that have been approved already?
Remedies evolves gradually. It doesn't have great lurching changes, but we have done some useful and important things, I think, or the Institute has. One of the sections I was afraid we would have trouble getting approved, and it sailed through with little dissent. We say that the language of general and special damages or consequential and direct damages is used in so many different and inconsistent ways, it's essentially meaningless and should play no role in the law of tort damages. That's now approved by the Institute. That I'm not sure judges will follow, but we'll find out. We have built on the earlier tort restatements and with respect to injunctions against tort to say clearly irreparable injury doesn't mean what it sounds like, and it's just a comparative question. Which remedy is better, all things considered, damages or injunctions? That's what the first two restatements of tort said, but they didn't elaborate and they didn't say it as clearly as they might have. We elaborated a lot and said it pretty clearly, I think. Rick, what else?
Well, the first thing I'd say is that if you look look at the first restatement of torts and the second restatement of torts, remedies is an afterthought. It comes in the 800s and 900s. It's like at the very end of the restatement. And, when I first started teaching and I was teaching contracts, it would be like the last week. You would like shove in whatever you could on specific performance and a little bit on restitution.
It's true of all restatements, and it's true of nearly all substantive law courses.
I think that the real innovation here is a project focused just on remedies. So just to explain a basic point that people who are not familiar with the restatement process may not realize, the first restatement of torts and the second restatement of torts was kind of a single project with a group of reporters and advisors, but all the way through all of torts. And torts is such a large subject, and the restatement of torts is so influential across the American judiciary and American law that the project was broken into parts, and it started in the 1990s. In fact, you introduced me as the Gary T. Schwartz Endowed Chair in Law. Gary T. Schwartz was my professor. He was on my dissertation committee when I was at UCLA, and he was one of the first reporters working on the third restatement of torts, working on the part called liability for physical and emotional harm. The project is still going, even when we finish, which I hope will be in 2027, 2 more years. There's still ongoing projects on defamation and, a few other things that need to be finished up. So it's this very long process, but we are the first reporters, I think, in the history of the restatement that are dedicated to focusing on remedies. And so one of my hopes is that although the substance is tort remedies, much of what we say is trans-substantive and can be applied all over. The other thing I'd say, to bring it back to the casebook, is we talk about important social and political choices that are made by remedies. And one of the ones that we highlight, pulling off the restatement, is how do you deal with damages for, say, a child who suffers a very serious injury for whom you can't predict kind of work effects, like what kind of job are they going to get, how much they're going to make. Many courts will allow the consideration of data based on race or gender in order to predict these things. And this ends up grandfathering in some past discrimination in a way that is completely unfair to these tort plaintiffs. And there have been a number of scholars who have taken the position that it shouldn't happen. And I was very proud. One of the proudest moments was when the Institute approved the part of our restatement where we said that it should be an average based on all children, of this age, as opposed to looking at race or gender statistics. And we talk about that in the book. And, I would underline the modern American remedies, and it's how we're trying to do contemporary cases and figure out what makes sense for today. We have to discuss history. People have to understand the difference between courts of law and courts of equity. But this is not a history class. It's a class of how to help your clients. I tell my students when I get into class, this is the class your future clients want you to take more than any other class.
Absolutely.
The point on race and gender neutral projections is not just for children, it's for adults as well. How much would this young adult have earned in her lifetime should not be predicted on the basis of how much other women earned in an earlier age. I'm glad that the Institute signed off on that. And there are a few cases that take that position, but for the most part, just entering race-based and sex-based data has gone by default without people thinking about it much.
Well, I want to congratulate you and thank you for getting that changed in the restatement, because you're exactly right. It will perpetuate systemic discrimination and things that should not be considered in a modern American remedies approach. It's interesting, too, that you mentioned how many courses, substantive law courses, just stick remedies into the very end. And you're right. It seems like it might make some sense to have the whole framework of the course rely on the idea of remedies. But yours is meant to be used with an independent remedies course, correct?
That's right. It's almost inevitable that remedies will be tucked in at the end of other courses. And when we cut the first year courses, torts, contracts, property, back from a full year to a semester, lots of stuff had to be cut, and remedies is one of the things. So there used to be a week or two on remedies, and now you're lucky if there's a day or two in torts and contracts. Yeah, our book is designed for a freestanding remedies course. It can be used in a lot of different ways. Teacher's Manual, we have 14 different suggested syllabi for different kinds of emphases.
Wow, that's a lot.
And different lengths of courses. So I doubt there are any 1 credit courses, but just in case we've got one. But 2, 3, and 4 credit courses, and with an emphasis on public law, private law, law, monetary remedies or injunctions. It can be used in a lot of different ways, but it's designed for a remedies course as such. It's designed for a full semester focused on remedies. And nobody gets to do that in the rest of the curriculum. And it is the course your client cares about most, right? Some repeat litigants are interested in establishing the precedent, but for the most part, people are interested, what do I get out of this? Right? How much money, or what does the other guy have to stop doing? How do we fix my problem? And remedies is where we do that.
I would add also that I don't think we've mentioned this, that there's a concise edition of the casebook. That one is going to be published in July, so it'll still be available in time for fall 2025 classes. Only in law could you have a book that's 700 or 800 pages and call it concise, but it really is something for teachers that are looking for a more streamlined approach to the course where all of the cases are in there. There's no case that's omitted, but the notes are cut down.
The notes are cut down by about a third.
Some instructors really like that because it focuses the students on the more key basic doctrinal points. And I like having the other notes because I can tell the students, make sure you read this particular note because we're going to talk about it in class. I should say another tip. One of the things I do is I post my PowerPoint slides for the semester in advance. And I tell the students, there's a lot of notes. You're not going to be able to read all the notes and you're not expected to read all the notes, but look at what's on the slides as things I'm going to talk about. And that will direct your attention to where you should devote your reading. But for those who want kind of that streamlined approach, that there is this other edition that we're in the process of putting the finishing touches on. And as I said, should be available in the summer in time for fall classes.
I'm not teaching anymore, but I was until recently, and I did tell students to read all the notes, but I told them they obviously weren't expected to memorize the notes. They weren't going to be tested on the details in the notes. But for the most part, my experience was the students reacted pretty favorably to those notes. They were informative, try to keep them lively. We try to use interesting examples. We obviously include the leading cases where we need to, either as a principal case or a prominent note. But we've got a lot of interesting examples in the notes, and the student reaction has been very positive.
Well, and I know that you've updated and given more extensive treatment to the Supreme Court's treatment of emergency relief and the standards for granting stays and injunctions pending appeal. I imagine that particular topic is getting a lot of attention just given current events that are going on.
So one of the hardest things is trying to keep the material manageable when there's so much going on and trying to keep up with it. And one of the things that we do is we prepare an annual supplement. It's online only, and it is free to the students and instructors. And so we go, a number of years between editions. I think the last edition was 2019. So, we're going 6 years. So there have been larger gaps in the past, but you don't lose out in terms of that's one of the, Doug said remedies evolve slowly. That's generally true, but it's not true for the Supreme Court's emergency docket, where there's just so much going on and there's just a lot of uncertainty about, what are the standards for stays and injunctions on appeal. And with the new Trump administration litigation, I imagine the next few years there's going to be even more that's going to be added. But people who use our book don't have to worry that they're going to be out of luck in terms of keeping up, because we'll be updating those supplements every summer. Those supplements usually come out by mid-July.
Well, I'm sure there'll be much to supplement in the coming years. Another thing that you've added is new material on the controversy about qualified immunity for police officers and other government officials and employees. You want to share what the new material covers regarding that topic?
Well, there are just an enormous number of cases, even at the Supreme Court. They've taken a huge interest in this. They're doing several cases a year. So even the notes, we have to pick and choose. We don't summarize all the Supreme Court cases even, but the newest cases are in there. And then the literature is also exploding. There are empirical studies now, how police are trained, whether they really know anything about clearly established law, about how many cases are settled, even despite how extreme qualified immunity seems to become. Cities still pay out lots and lots of money in settlements, and studies of large samples of reported cases to see whether qualified immunity is achieving the goals the Supreme Court thinks it is. And we keep the unit to manageable length, but given that constraint, summarize as much of that literature as we can. It's a huge debate. The Supreme Court shows no sign of backing down. Republicans in Congress are opposed to any kind of legislative reform, but there are dissenting judges, including very conservative dissenting judges in the lower courts. And so we cover as much of that as we can. And we treat immunity as a remedies issue because it blocks the remedy. And no matter how badly you were mistreated, you don't don't get a remedy if your defendant is a sovereign or if your defendant has qualified immunity.
Well, certainly your 6th edition of Modern American Remedies, Cases and Materials will be very popular among anybody who's teaching remedies already, given that it is the leading book in the field and now with much updated material. But if you were talking to a new faculty member, a young faculty member, or early on the tenure track, and who was considering maybe teaching remedies, what pitch would you make as to why this should be a subject they should consider teaching?
I've got a few things to say on that. One is it's a great capstone course because usually you're getting students. In California, it's a bar class. Almost everyone's taking a remedies class, or a good portion of people are taking a remedies class. I think it's taught every semester at UCLA, and it was like that when I taught at Loyola as well. But you get back your first-year students who you had in torts or contracts or property. You get them, when they're seasoned and jaded, and you get to see them again. But it reminds them, oh yeah, Hadley versus Baxendale, Paul's graph. Like, I didn't see how these things were connected. I didn't realize that how dealing with easements and property could be connected to questions of injunctions generally. So the students see a lot of connections. They see connections between private law and public law. There's not another course where you're one day reading a private law case, a contracts case, and the next day you're reading about governmental powers and questions about presidential authority. So it really brings together all of those things. But this is what I would tell a young teacher. I'd say two things. Number one, the teacher's manual just makes it so easy because it's a turnkey class. If you read the teacher's manual and you read the book, you'll be able to teach this course. If you're a smart person and a good instructor, you've got everything you need self-contained in those two materials. And the other thing is, you'll get good student evaluations because students' expectations for remedies are so low. I think it's going to be a boring class where what you're going to do is go through something mechanical, and it turns out it's actually some of the most important and fascinating issues of our time. And Bush versus Gore, I'm an election law person, Bush versus Gore ultimately turned on a remedies question. Who was going to be president of the United States was a remedies question. It was not no longer an equal protection question. And that makes it exciting and interesting, I think.
The other thing about student reaction is, and you don't necessarily get this while you're teaching the class, but I routinely hear from alumni, this is the most useful course I took in law school. I never hear that about any of my con law courses. This is the most useful course I took. This is the only casebook I kept, because if you litigate, remedies is the bottom line. It's what you're fighting over. But also transactional lawyers benefit immensely if they have some idea what will happen if this deal goes bad and what the options will be. So alumni report that this was a very useful course.
Well, that's really wonderful. Again, congratulations on Modern American Remedies, Cases and Materials 6th edition, and that there'll also be a more concise edition published this summer. And before we conclude, I wonder if each of you would address what your predictions are for the future of legal education in the coming decade. Doug, you want to start?
Well, if I could predict the future, I'd be wealthy in the stock market. I read just the other day in the New York Times a tech entrepreneur with an AI company saying hallucinations will never go away. They will always be with us. That makes AI completely useless for any of the work that I do. So I'm inclined to think it's not going to revolutionize legal education to the extent that some of us hope and some of us fear. As to other changes, what we'll do to law firm practice, what we'll do to the job market, I don't know. I think I may have spent my career in a golden age for legal education when everything was expanding and there was lots of money and we got raises far beyond anything we've been led to expect. Maybe that will continue. Maybe that will wane away. But the short answer is I really don't know what's going to happen to legal education going forward.
I just add that I think we're in a period of profound, not just technological, but political and social change. And when there are these kinds of conflicts, that leads to litigation. And probably in the United States more than anywhere else, since we have a tradition of litigating our problems and seeing them go to the courts. And so I think, that there's a reason that applications are way up right now to law schools. And I think part of it is the uncertainty of the economy, and people are parking themselves in law schools for a few years. But part of it is that people want to feel like they can make a difference, and they see law as a lever for doing that. And I think so long as we continue to be in these kinds of tumultuous times, law is going to be essential, and no chatbot is going to be able to replace a smart thinking lawyer working through these problems, or the judge who's going to have to make a judgment call, who's not going to be letting a computer make the very hard decisions about how to balance these conflicting priorities in this difficult period. So I think law is going to still matter. And of course, remedies, the bottom line is always going to be what matters to those who are not lawyers, who are trying to figure out what exactly does all of this mean.
Well, thank you both for discussing the 6th edition of Modern American Remedies through Aspen Publishing. And if you enjoyed the conversation with Doug Laycock and Rick Hasen, I hope you'll listen to additional thought leaders in legal education on the Aspen Leading Edge podcast, wherever you get your favorite podcasts. Thank you.